Confidentiality, Anitra Bular, Los Angeles Pacific University. What is confidentiality? Confidentiality is the ethical responsibility as well as the legal and professional duty to safeguard clients from unauthorized disclosures of information given in the therapeutic relationship. Professionals must not disclose information except when authorized by law or the client to do so. Because confidential rights belong to the client, the counselor may legally and ethically reveal a client's confidences once the client waives his right. There are, however, limitations to the agreement of confidentiality. For example, in circumstances where the counselor has the duty to warn and to protect, confidences must be broken. Important terms related to confidentiality are privacy and privilege. The client's private information has the right to be protected from visibility, access, and intrusion by others. The counselors must take care to safeguard private information in areas where there is more potential to unintentionally invade a client's privacy. Examples of such situations are employers' access to an applicant's or an employee's psychological tests, a third party's access to medical records, or a parent's access to their child's school and health records. Also to be considered is the possibility of a chance meeting or a scheduled meeting outside of the professional setting. If a counselor meets a client in public, revealing their relationship to the client would be an invasion of privacy as well as a breach of confidentiality. Privileged communication is a legal concept that generally bars the disclosure of confidential communication made to a psychotherapist from any judicial proceedings or court of law. Privileged information ensures that a client's personal and sensitive information will be protected from exposure by counselor in legal proceedings. This, too, is a right belonging to the client. If the client waives this right, the counselor is then obligated to disclose only the information which is necessary to specific individuals or agencies which are stated by the client. These three concepts contain guidelines helpful for adhering to the ethical codes for conduct when facing an ethical dilemma. Mary Alice Fisher, a psychologist and the founding director of the Center of Ethical Practices, designed a six-step ethical practice model for protecting confidentiality rights, which addressed legal mandates in an ethical context. First one is preparation. In order to thoroughly cover limits to confidentiality, it is important to have knowledge of legal limitations as well as any personal moral principles which may be relevant. After clarifying these limitations, the counselor should then devise an informed consent reflecting his ethical position as well as confidentiality limits. It is also a good idea to go over the document with the client to make certain they understand the items and to address any areas of concern. The second one is tell clients the truth. Again, in this step, it guides the counselor to obtain the client's consent and acceptance to confidentiality limitations, as well as giving an explanation of the professional relationship dynamics which may affect the client's disclosed confidences. Thirdly, was to obtain truly informed consent before disclosing voluntarily. Only disclose information when it is legally unavoidable. And before doing so, make sure to get a signed document of consent from the client. So if there's a signed consent that when in intake where the client has already agreed to these terms, 6 months later when there's something actually legal thing actually comes up, then it would be wise to have them sign again, stating that they're waiving their rights and or that they agree with disclosure. Okay, respond ethically to legal demands for information. The counselor is to notify the client of pending legal demands for disclosure of privileged information. Thereafter, minimizing disclosed confidential information as much as legally possible. So when you do give out the information, just giving out only the information that's required and not giving anything additional, and making sure that you're applying to the law. Avoid preventable breaches of confidentiality. This involves a number of things: avoiding making unethical exceptions to confidentiality rule, establishing and maintaining policies directed at protecting the client's confidentiality, monitoring, note-taking, and record-keeping practices, avoiding dual roles that will create conflicts of interest in the courtroom, anticipating legal demands and the response to the requirements, encouraging clients to use protective measures on their own behalf, and not confusing laws that permit disclosures with laws that require disclosure. For example, disclosure of privileged information is permitted when a counselor is working under supervision. However, disclosure is required when legally mandated, when a client poses a threat to themselves or others. Lastly, talk about confidentiality. Talk about confidentiality, exhibit the ethical behavior, make sure to educate clients, students, supervisors about confidentiality as needed. As mentioned before, there are limitations to the confidentiality rule. It is the responsibility of the counselor to make clear any ethical or legal restrictions on confidentiality. Whatever those limitations, they should be listed on the informed consent document and gone over verbally with the client, clarifying each point as necessary. As previously mentioned, there are permitted disclosures as well as required disclosures. Some permissible disclosure requirements include situations when clerical assistants handle the confidential information, like office manager, or when the counselor consults with experts or peers for advice, when the counselor is working under supervision, so like a counselor in training, and when the client requests a release of information to like perhaps their doctor or to an attorney. Required disclosure would be a situation when clients pose a threat or a danger to themselves or others, or when the client discloses intent to commit a crime. Statutes involving child abuse or neglect or elder abuse, and information ordered by a court of law. HIPAA, the Health Insurance and Portability and Accountability Act of 1996 is a federal law that contains detailed provisions regarding client privacy, informed consent, and transfer of records. HIPAA regulations require those who are under HIPAA to provide their prospective clients with a clearly written information of how their healthcare information is used, disclosed, and stored. HIPAA privacy rule was designed to provide uniform level of privacy and security at a federal level. It was developed out of concern that information transferred electronically would lead to widespread gaps in client confidentiality. It requires technical, administrative, and physical safeguards to protect the security of health information in electronic form. So there are 4 standards for the HIPAA Act, which are privacy requirements, electronic transactions, security requirements, and national identifier requirements. For the privacy requirements, it requires practitioners to take reasonable precautions in safeguarding patient information, limiting the disclosure of protected information, payment management, psychotherapy notes, and a client's medical records and treatment activities. Electronic transactions require HIPAA's goal here is to create a universal language for electronic communication so that healthcare providers can communicate with one another in a common language. Security requirements. Minimal requirements are defined in HIPAA, which are designed to safeguard confidential information and prevent unauthorized access to health information. Lastly, the national identifier requirement. Healthcare providers and health plans are required to have national identification numbers that identify them when they are conducting standard transactions. Only mental health providers within the covered entity of HIPAA are subject to these requirements. Those who are not covered are not required to comply but may choose to do so. Duty to warn and to protect. Duty to warn and to protect applies to those circumstances where a case and statute requires the mental health professional to make a reasonable effort to contact the identified victim of a client's serious threat of harm or to notify law enforcement of the threat. Duty to protect applies to situations in which the mental health professional has a legal obligation to protect an identified third party who is being threatened. In these cases, the individual usually has other options in addition to warning the person of harm. Counselors may be held liable of responsibility to protect the public from dangerous acts. Violent clients is neglected. There are a number of landmark cases which contributed greatly to the case laws set in place in respective states governing the duty to warn and to protect. Spearheading these laws is the Tarasoff case, which resulted in the duty to warn of harm to self and others, as well as the duty to protect. This after Tarasoff was killed having no warning that her life was in danger, even though the authorities were warned that she was in potential harm. Thereafter, the Bradley case resulted in the duty to negligently, that's a good word, release a dangerous client after a client whom was released from a mental hospital committed murder soon after. The third legal ruling was in the Jablonski case, and that was duty to commit a dangerous individual. So when a client was not involuntarily committed after the failure to obtain his prior records, which led again to another murder victim. The fourth legal ruling was in the Hetland case. The ruling extended the duty to warn to anyone who might be near the intended victim or who might also be in danger. So it extended the coverage from not just the third party who might be harmed, but anyone close to them. In this case, this was after the victim's child was placed in harm's way. So there are guidelines for cases involving the duty to warn and protect. So some are know the relevant laws in your state. Inquire about a client's access to weapons, homicidal ideation, and intentions, including whether a specific victim is involved. Consider all appropriate steps to take and their consequences. Obtain prior medical and behavioral history. Know and follow the policies of your institution. In case of immediate threat by a client, do not hesitate to take actions to protect yourself, and document all actions taken and the rationale behind each decision. So being prepared for the eventuality of dangerous clients will give the counselor a better awareness of what to do in these type situations. Additionally, the counselor liability will be reduced by following these guidelines for a judicious course of action, demonstrating adherence to the standard of care expected of a mental health care professional. In conclusion, confidentiality in counseling requires that all client records as well as disclosed information be safeguarded and recorded with respect to the client's privacy. Staying within the guidelines for confidentiality along with its limitations can be tricky. Fisher's six-step ethical practice model was designed to help the counselor navigate the various ethical codes and mandates more easily and effectively. The HIPAA Act assists mental health professionals within its covered entity to maintain confidentiality when collecting, transferring, and storing privileged information about clients. Duty to warn and to protect laws have been created which place limitations on confidentiality in order to protect the public from dangerous clients. Legal precedences for these laws began with the Tarasov case, whose guidelines are still relevant today as mental health and violence are alleged to have a connection between them. The ethical codes and mandated laws which support the principle of confidentiality are of great consequence to the counselor-client relationship. Mental health professionals should know and adhere to them, making judgments that are within the parameter of acceptable practice. Dual relationships, Anitra Bular, Los Angeles Pacific University, Psych 475. What is a dual relationship? A dual or multiple relationship occurs when a professional assumes two or more roles at the same time or sequentially with a client or with someone who has a significant relationship with the client. In most cases, having a personal relation with a client can have a negative effect on the professional relationship, causing one of the relationships to suffer. Ethical codes caution against involvement with clients, which may impair the counselor's judgment or objectivity, affect their ability to provide effective services, or result in harm or exploitation of the client. Examples of dual relationships. A dual relationship could result from taking on more than one relationship in the form of instructor and therapist, where the therapist has their client as a student in their class, the blending of professional and non-professional relationships, such as a counselor taking on a friend as a client, providing therapy to a relative, having your sister-in-law as a client, for example, socializing with a client, being on the same baseball team as one of your clients, or having a business relationship with a client where maybe your client is your housekeeper. Foreseeable and unforeseeable dual roles. Dual roles differ in terms of their predictability or foreseeability. Therefore, they can be classified as foreseeable and unforeseeable. Foreseeable dual roles are those that the therapist has time to consider or contemplate. For example, considering whether or not to provide psychotherapy to someone with whom you have had a prior social or business relationship. In cases of contemplated dual relationships, APA 2002 Ethical Standard 3.05A cautions to refrain from entering into a multiple relationship if it could reasonably impair the therapist's competence or objectivity. Unforeseeable dual relationships are those that cannot be reasonably foreseen. For example, joining a yoga studio and then finding out that the instructor is one of your clients. In the case of unforeseeable dual relationships, APA 2002 Ethical Standard 3.05B states that if a therapist finds themselves in dual relationship due to unforeseen circumstances, they must take care to resolve the issue with regard for what is in the best interest of the client. Conflict of interest. Independence of judgment can be compromised when a therapist has a conflict of interest. Such conflicts often arise in dual relationships as the respective role expectations may conflict or compete. For example, the therapist who has a client that is also a student may deal with conflicting expectations from their client student when the student expects leniency in class because the instructor knows they are in crisis, for example. Having one or more interests can also place a strain on the therapist's ability to remain objective in the provision of competent counseling services. For example, will the instructor be able to withhold judgment of the client when he witnesses behavior in the classroom that contradicts what is being said in session? So things to consider, questions to consider when a therapist is operating in a professional role and is contemplating a dual relationship with a client. There are some questions that should be considered in the decision-making process. Like, is entering into a relationship in addition to the professional one necessary, or should I avoid it? Can the multiple relationship potentially cause harm to the client? If harm seems unlikely, would the additional relationship prove beneficial? And if so, is it beneficial to the benefit focus more on the client, or is it focus more on the therapist? Is there a risk that the multiple relationship could disrupt the therapeutic relationship? And can I evaluate this matter objectively? It would also be prudent to consult with a colleague to help identify any ethical blind spots on the part of the professional. Boundaries. There is the potential for boundary crossing, which often involves clinically effective interventions such as self-disclosure, home visits, non-sexual touch, gifts, or bartering. Boundary crossings such as these are not unethical and may not constitute a dual or multiple relationship. For example, a therapist is accepting an invite to a client's graduation party. Although it is not unethical, it can pave the way to boundary violation, which occurs when a therapist crosses the line of decency and violates or exploits their client. A gradual erosion of boundaries can lead the therapist down a slippery slope. This phenomenon suggests that once a therapist crosses a boundary, they will have the tendency to engage in a series of increasingly serious boundaries violations, which can lead to a progressive deterioration of ethical behavior. However, there are advantages to boundary crossing. Although boundary crossing has the potential to lead to violation, resulting in harm to the client, it can often be a part of a well-constructed plan, which could increase therapeutic effectiveness. Forms of treatments such as behavioral therapy, cognitive therapy, humanistic therapy, and existential therapy, for example, support helpful boundary crossing. Examples of beneficial boundary crossing in therapy are self-disclosure. Respective cognitive and behavioral therapists endorse self-disclosure as a way of modeling, offering an alternative perspective, increasing therapeutic alliance, or as a way to level the playing field. A therapist may join their client with an eating disorder for lunch or dinner as part of the therapeutic process. A therapist who works in poor neighborhoods may engage in bartering to give access to mental health care to individuals who otherwise could not afford it. And going on a walk with a client who is depressed and medically non-compliant. Another would be a child psychologist may regularly engage in appropriate touch and hugs and even provide snacks or drinks for their young clients. And lastly, a therapist may accompany their client who may be anxious, grieving, or fearful, respectively, to events such as visiting the gravesite of their loved one to help facilitate the grieving process, or with a client or accompany a client to a 12-step meeting. Managing dual relationships in rural communities. Dual relationships are subtypes of boundary crossing. Therapists who practice in rural and small towns encounter numerous unavoidable dual relationships in their daily lives. Individuals working at the local grocery store, dentist office, or elementary school may also be the therapist's client. With the high frequency in which the therapist may find themselves managing the inevitability of dual relationships, it can become difficult to balance their personal and professional life. Therapists in small communities can minimize risk and practice ethically and professionally by following these steps. Obtain informed consent. Well-informed clients, when a client is well-informed, it's helpful when unavoidable dual relationships or boundary crossing occurs. Document thoroughly. In the event that there is a legal matter, documenting the types of boundary crossing that occurred can be helpful. Set clear boundaries and expectations for both themselves and for the client. Pay attention to matters of confidentiality. In small towns, confidentiality can easily be unintentionally broken because everybody knows each other. And get involved in ongoing consultation or a peer supervision group. And this could be helpful for both getting advice from your peers and for accountability. Conclusion. Dual relationships occur when therapists take on an additional role with a current client or with someone who is close to that client. Conflict of interest is often a consequence, that can complicate the client-therapist relationship. Another difficulty that may arise is the crossing of boundaries, which can lead to boundary violation. While in traditional forms of therapy, boundary crossing may be frowned upon, it is seen to be helpful in modern therapies such as rational and humanistic therapies. However, it is important to implement boundary crossing according to the client's unique situation, considering factors such as their condition, personality, and culture. It may be more difficult to avoid dual relationships and boundary crossing in small towns and communities. Nevertheless, taking steps to minimize risks will promote ethical and professional practice. Confidentiality and dual relationships. Age. Anitra Bular, Los Angeles Pacific University, Site 475. This presentation will cover both confidentiality and dual relationship in respect to age. The majority of the presentation will reflect the impact of these issues on the child-adolescent client, with some consideration for the geriatric client where concerned. Given the prevalence of cases involving children and adolescents, it is important to be well informed regarding ethical issues and the ethical treatment of youth. Confidentiality is one such issue. Many therapists and school counselors consider issues of confidentiality the most often experienced ethical dilemma. Confidentiality challenges in cases involving minors. Some factors which make confidentiality challenging in cases involving minors include the therapist bearing primary responsibility for for records and other information about a child client, even more so than with the adult client because the child cannot decide independently. Therefore, the therapist must strive to manage the child's confidentiality in his or her best interest, as well as in the best interest of the family, while considering carefully the wishes of the child, parents, and other involved parties. Next, the minors are usually not afforded full confidentiality, partly because they do not bear full legal responsibility for themselves. The rights of minors vary considerably. Minors under the age of 12 do not have confidentiality rights. However, parents, depending on the jurisdiction, generally have legal control over confidentiality for non-emancipated children under the age of 18. Lastly, therapists often experience significant tension between the need to reasonably maintain confidentiality of the child or adolescent client's records and the therapy process itself, and to also provide enough information to the parents and other responsible parties for them to fulfill their own responsibilities for the child's well-being. Therapists should keep in mind that older children, adolescents, can be legally entitled to privacy in areas where their parents might reasonably want to be informed. For example, in some states, adolescents are allowed confidentiality for obtaining certain medical services. If there is a situation where the therapist feels that the information needs to be passed on to the parents, they should be convinced that a more crucial issue than confidentiality is at stake. On the other hand, the therapist should be aware that if they withhold information from parents and that information later results in injury to the child, they assume responsibility. For example, in cases where the use of controlled substance is involved. The best course of action is to do what is in the best interest of the client. If that means breaching confidentiality, the therapist should give the child options for disclosing information to their parents. These may include the child telling the parents in the presence of the therapist telling the parents in the presence of the child, or the therapist telling the parents while the child waits outside the room. Exceptions to confidentiality. In some cases, the parent may not have the right to information about their child's treatment. Those might include when a parent has lost or given up their parental rights. For example, a biological parent of an adopted child would not have a right to treatment information. Or when a court order specifically prohibits the parent from accessing the child's information, and when the child is emancipated, which means when a minor becomes legally responsible for their own care under the age of 18. It is important that the therapist discuss any and all confidentiality concerns with the child and their parents. This is typically addressed during the informed consent process. Importance of confidentiality to the minor. Therapeutic confidentiality is key to effective treatment for numerous reasons, including building and preserving a strong therapeutic alliance. The benefits of confidentiality for children include increasing cooperation in treatment. The child or adolescent client will not feel the need to disclose information that they don't want to share with their parents if there is no guarantee of confidentiality. Often, that very information is what is needed to be disclosed in therapy. It ensures a child gets effective treatment. If the child is unwilling to disclose information, it makes it harder for the therapist to be able to help them with their needs. Protecting the child from risk of abuse or homelessness. Because not all parents have unconditional love for their children, it could be harmful for them. For example, if the parent were to beat them or disown them for their sexual orientation if that information were to be disclosed. Protecting child from third parties. Confidential information can be used for a wide range of purposes: bullying, marketing, even stealing a person's identity. So even though the child may not have the right to confidentiality from the parent, they still have a right to privacy from third parties. Lastly, improving the parent-child relationship. When a child can openly discuss their feelings in therapy, their relationship with others, including their parents, will improve. Limitations to confidentiality. Mental health providers have an ethical and legal obligation to protect children and older adults from abuse and neglect. Whether working with children or adults, therapists are expected to know how to assess potential abuse and to report it in a timely fashion. Confidentiality does not apply in cases of child abuse and neglect, nor does it apply in cases of elder abuse. If a child or the elderly disclose that they are being abused or neglected, the professional is required to report the situation under penalty of fines and imprisonment. Such matters constitute reportable abuse. Mandatory abuse is designed to encourage reporting of any suspected cases of child or elderly abuse. The therapist is advised to err on the side of reporting in uncertain circumstances. There are several steps that a therapist can follow to make sure that he or she is handling a suspected abuse situation ethically. First, know the state statutes and review them regularly. Second, consult with trusted supervisors or colleagues, making sure to protect confidentiality in the process. And third, when there is still uncertainty on whether to report or to proceed with a report, contact related professional associations for guidance. Protection from harm, minor. As previously mentioned, therapists are ethically and legally obligated to breach confidentiality in situations where there is a duty to protect. Those circumstances involve abuse, for minor, involve abuse and neglect, consisting of emotional abuse, physical abuse, and sexual abuse, self-injury, such as cutting or burning, risk of suicide, and if the therapist makes a determination that a client is at risk for suicide, they should take the least intrusive steps necessary to prevent harm, and harming others. In the case where there's a school counselor, for example, and she fears that one of her clients might do a school shooting or something like that, it would be mandatory for her to report that. Protection from harm, elderly. The abuse of older people and other vulnerable adults deserve the same kind of attention that is paid to abuse of children. States vary in reporting requirements for elder abuse. Some states permit the therapist to break confidentiality and file the report, and some states require that therapists do so. However, all 50 states have statutes related to elder abuse. In 45 of those states, mental health professionals are mandated to report neglect or abuse. The major types of elder abuse are physical abuse, which involves the use of physical force that often results in bodily injury, physical pain, or impairment. Sexual abuse consists of non-consensual sexual contact. Psychological or emotional abuse, kind of abuse, may include verbal assault, insult, threat, intimidation, humiliation, and harassment. Neglect can be either intentional or unintentional, and it also can be self-inflicted, where the elderly is not taking care of themselves, or inflicted by others. Abandonment involves desertion of an elderly person by an individual who has assumed responsibility for being their caregiver. And lastly, financial or material exploitation is illegal or improper use of an elder's funds, property, or assets. Helpful professional associations. From both the ethical and legal perspective, therapists are expected to inform clients about the limits of confidentiality pertaining to the duty to report cases of abuse. Although therapists are likely to accept their professional responsibility to protect innocent children and older adults, they may have difficulty determining how far to go in making a report. It can be difficult to reconcile ethical responsibility with legal obligation. Therefore, it is important to develop a clear position regarding the assessment and reporting of child and elder abuse. Fortunately, there are professional associations in some states which provides legal assistance to help therapists make a determination about when and whether to report abuse. The National Center of Elder Abuse, NCEA, is dedicated to educating the public about elder abuse, neglect, and exploitation. It is a recognized resource for policy leaders, practitioners, and prevention specialists, to name a few. Child Protective Services is also useful in helping to determine when to report a situation of child abuse or neglect. Benefits of dual relationships. Similar to adult clients, dual relationships can be beneficial to the child client. There are advantages to crossing boundaries within those relationships in certain circumstances. For example, the school counselor can do a lot to build a relationship with a student by attending their school play, music recital, or sports event. Or when the youth counselor at church is able to work with the youth whose faith is an important part of their therapeutic treatment. In some cases, therapists have reported that by attending a client's graduation, they were able to demonstrate appropriate, genuine concern and nurturing toward the youth. These benefits should be documented along with any consultation sought about the matter. It is good to be aware and to safeguard against dual relationship boundary issues which may negatively impact the client. However, being too dogmatic about avoiding dual relationships diminishes the essence and authenticity of the respective school counselor, social worker, or church youth counselor. Interrelatedness. In situations where the church youth counselor who has clients from his own church or the school counselor teacher who has clients in her classroom, they are not only dealing with issues of confidentiality, but also with that of dual relationships. In this way, the individual ethical issues are interrelated. The success of effectively navigating dual relationships is dependent upon adherence to confidentiality guidelines. Educating all parties involved on the importance of confidentiality can lessen the potential of harm to the client. Counseling children and adolescents certainly can be a complex and challenging process. Despite the challenges that therapists face when working with youth and their families, it is possible to work ethically and as well as effectively with this particular population. Resolving ethical dilemmas is most often a deliberate process that entails considering possible resolutions and their implications. Consulting with colleagues is an important part of resolving ethical concerns. Great effort must be made in protecting youth and elderly from harmful situations such as abuse and exploitation, even at the risk of damaging the therapeutic relationship. Dual relationships with children, as with adults, should be avoided. However, in cases where it is unavoidable, the therapist must take care to protect confidentiality and define clear boundaries. Although it is necessary to define those boundaries, it can also be beneficial for some treatments. Children and adolescents have greater need for mental health services than ever before. It is important to remember that great and life-changing good can be done when intervening in the life of a child. Serve them with caution, but serve them nonetheless. Now we're moving on to dual relationships, the minor. When working with youth, even more so than with adults, it is important that the therapist engage in thoughtful deliberation about the possible motives and consequences for being involved in an ethically appropriate way in the child or family's life outside of therapy. Therapists working with a child or adolescent may employ considerable influence in some circumstances or may have difficulty maintaining sufficient rapport for therapy. Therefore, the impact of contact outside therapy must be carefully weighed along with the client's and parents' wishes. School counselors must often function in multiple roles, such as counselor, teacher, and chaperone. This can easily place them in dual relationship scenario. Social workers also are likely to face the inevitability of the dual relationship due to the nature of their work, and youth church counselors are also more likely to find themselves in a dual relationship with a child-adolescent client. No matter the circumstances under which a therapist finds themselves in a dual relationship with a client, it is important to establish boundaries at the onset. Because the therapist working with a minor may, in a sense, be forced into multiple relationships due to the various parties which may be involved in the child's therapeutic process in one way or another, dual multiple relationships can present a challenge. Again, the best course of action is to do what is in the best interest of the client, making sure to clarify boundaries with each of the parties, first during the informed consent process, and then as challenges arise. Counselors must exercise the skill and care of a reasonable professional to identify clients who are likely to do physical harm to a third party, protect third parties from a client judged as potential to be dangerous, and treat those clients who are dangerous. Counselors faced with potentially dangerous clients should take specific steps to protect the public and to minimize their own liability. Examples of this would be keeping accurate notes of threats and other client statements, seeking several consultations with peers to gain advice, recording steps made to protect others. Most states permit or require counselors to breach confidentiality to warn and protect potential victims.